Ready for dictation. Start on the question as to whether there was absence from work and no termination. Stop. In the claim statement before the tribunal, respondent alleged that his services had been terminated and the manager has illegally dismissed him from service. Stop. Preliminary objections were filed by the appellant, taking the stand that the reference was not maintainable since government could not have come to the conclusion that there has been termination of service. Stop. It was reiterated that there was no termination of service and it was still open to the respondent to resume work. Stop. This preliminary objection was filed on 7/11/1994. Stop. On 21/2/1995, respondent filed a reply therein refusing to resume work. Stop. On 25/4/1995, the appellant filed rejoinder against the claim statement and again offered that the respondent could rejoin. Stop. Evidence was led to show that there was no termination of service and the respondent could join at any time. Stop. The tribunal in its award held that the termination was illegal and reinstatement with back wages was directed on the ground that even if respondent had started a bottle shop, he could not be said to be gainfully employed. Stop. Subsequent to the award, the appellant again offered respondent the option to resume duty pending challenge to the award in the writ petition. Stop. Respondent refused to resume duty. Stop. On 8/5/1999, as noted above, writ petition was filed before the High Court challenging the award. Stop. On 26/5/1999, High Court directed the appellant to deposit the wages with the tribunal and the respondent to report for duty. Stop. On 13/7/1999, appellant asked the respondent to join duty. Stop. Respondent again refused to join duty. Stop. Subsequently, also the appellant asked the respondent to resume duty and on 29/7/1999 deposited 50% of the back wages with the tribunal. Stop. Appellant requested the Deputy Labour Commissioner to depute an inspector with a direction to direct the respondent to resume duty. Stop. On 6/7/2000, the Assistant Labour Commissioner persuaded the respondent to join duty. Stop. The High Court dismissed the writ petition holding that the termination was illegal and that the respondent had not be gainfully employed after termination of service because self-employment cannot be treated as gainful employment. Stop. Para. In support of the appeal, learned counsel for the appellant submitted that contrary to this court's view, the Labour Court and the High Court have held that self-employment is not gainful employment. Stop. It is also pointed out that there was no indication in the claim petition that he was not gainfully employed. Stop.